Due process best practices that we just learned from our previous presentation is we want to make sure that we're keeping good records, right? We want to make sure that we're following our court rules. We want to make sure that we're explaining our decisions, and also that we're protecting our confidentiality. Right, so in keeping good records, how do we do that? Right, and how are we making sure that we're keeping good records? The easiest way of making sure that we keep good records is to have written records, right? And written records, why do we need it? You know, historically, a lot of our stuff has been oral. We've talked about it. We haven't necessarily written things down. But why should we consider moving towards writing things down, right? And the first reason is written records, documents, or notes. It really helps to create a record of the hearing or a record of what's going on. We can also utilize handwritten notes. We can utilize video recording equipment like we are here. We can utilize audio record equipment or even videotape records. Another reason is that it may be helpful when we're reviewing a particular case and we're drafting orders. So let's say that we have a judge who is really hearing the case and the clerk is going to be writing the order, right? If the clerk isn't paying 100% of attention, or even if there are some ambiguities, we want to make sure that we have a written record or some kind of record of what happened so that that particular judge's order can be accurately captured in his order that may be written by the clerk. Another reason, and a really important reason, is that if you are developing or if you have an appellate court in your communities, that the appellate courts really need a record to review in order for them to review what possibly could be a decision that needs to be overturned. If there isn't a record of what happened, then the appellate court really doesn't have anything to review. And then the final reason is that, let's say that it may be needed if a state court or a other agency may want to review the decision of your courts, right? So we have something that maybe, let's say we have a case that's being transferred outside of tribal court to a different jurisdiction or to maybe a state agency, and they want to review exactly what happened in that case and what happened, with your court. It's really important that we have written records to show them exactly what happened and what we did or what we may not have done. And so the next thing is, you may be asking, what do we consider is a written record? Right? And so in a case, we want to make sure that we're sending all parties to the case copies of the following documents, right? We want to make sure that we're sending them all copies of the petitions, letters to the courts, and other correspondence from the parties. So you're really going to have two parties in a case. We're going to have the petitioner or the plaintiff, however you want to phrase it, or we're going to have a respondent or the defendant. So anything that's filed by either of those parties, we want to make sure that we're sending out to everybody, and that is considered a written record. The second thing, yes, sir. And
how should we keep the records?
Good question.
We always get that question, how long do you have to keep your records? My philosophy is you keep them forever, but then I'm getting some pushback at my court that we can't keep them forever. If you have a way of digitizing, putting on the computer your court files, then you actually can keep them forever without dealing with storage problems, but then you still have to safeguard them. So my suggestion is that you, within your tribal government, come up with a retention plan of some kind, though you'll likely have to have a separate one just for the court files. For adoption records, you want to literally keep them forever because an adoptee may be 50, 60 years old and they want to be able to gain access to those records, and so they need to be available. A guardianship or divorce or custody might not need to last that as long as forever, but you still want to be able to have folks who want to gain access to have those. We ran into, for child support cases, the files needed to last not just until the children that child support was about turned 18, but until the debt was owed, the back support was actually paid. So you needed to keep records as long as somebody still owed a child support debt. So there's no easy answer to that other than it's one thing to put, as you're developing your court, to put it on your list of things to discuss and have a plan on how to do it. And no one person is going to have the answer to that. Just form a task force or a small working committee and figure out what's going to work for you. And that that's a solution. It's not an easy, it's a good question, but you don't have an easy answer.
Very good. Thank you, Joe Bednar. And we will actually, our department will try to do some research on seeing what other tribes are doing as far as how long they're keeping records, and we'll make sure we try to address it in our judges training in the fall. So thank you for that great question. And the other thing we want to make sure we're sending are what's considered a written record are court notices and hearing. Right, so anything that the court generates is going to become part of the court record. It's also considered a written record. And the last thing we want to make sure we're doing is, best practices is we want to make sure that we're making a written record of what is sent, when it was sent, and who it was sent to. And how that's normally done is through a court docket, and we'll go over a court docket in a few slides, but we want to make sure that we're doing that for all things that we're sending out. Okay, so you may want to ask, where do I send these records, right? We have some written records, where do we send them? The best answer is that we want to make sure that we're sending it to the most current address for each of the parties and everybody that we're sending their records to, right? And we may run into a situation that their most current address is not known. If that's the case, we want to make sure we try to send it to the last known address. Right? In the villages, it's maybe easy, when people move from here to there, but sometimes we don't. And if we send it to their current address and it comes back, if we send it to our last known address and it comes back, then we would move on to number 3 here. So if you've sent it to the current address, you've sent it to the last known address, and it's not being received or receiving it back, we just want to reach out and pick up the phone and maybe call their relatives or call friends in the neighborhood or in the community and ask, do you know a good address for this person, and update that address. A lot of the times, when they're filing things with the court, documents with the court pleadings, it asks specifically for their current address on there, so we can take it from there. But in the cases where people are moving out of the community or people are moving and they're not notifying the court, this is how we should really approach it. Okay, so let's discuss really quickly, and I know that we all work in the field here, so you all know how to begin a tribal court case. I just wanted to really just detail really quickly the ways that we can begin a tribal court case. And there's really essentially 3 ways, right? The first one is through a petition to use the tribal courts. And that petition can be filed by tribal members, it can be filed by witnesses, by victims, or a combination of different petitioners against an offender or a violator that really details the circumstances of that. It details that they want to seek relief in tribal court. The other way is through a complaint, right? And the complaint is generally going to be filed by, let's say, a VPSO, a VPO, or a TPO, and they are filing that for a violation of tribal ordinance or tribal law. And the last one is going to be through referrals or transfers from other courts. If you remember in our last training, we talked about intertribal court and how we receive cases from intertribal court situation. So the third way that we can go ahead and use the tribal courts is going to be through referrals or transfers from other courts. And really briefly, the petition to use tribal courts, right? There's some important information that we should make sure that the courts are looking at these petitions to make sure that this information is included. Of course, we want to make sure that we know the names of the parties. So we want to make sure we have the name of the petitioner, or if there's more than one petitioner, we want to have those names. We also want to make sure that we have the names of the respondents, or the defendant, or the person whom the complaint against is going to be filed. And then we also want to make sure that we're including, or that they're including a description of the circumstances that's surrounding the petition to use tribal courts, and also the reason for seeking, relief in tribal courts, or why they're requesting tribal court involvement. And here is just a sample petition to use tribal court. Again, this is one of these sample forms that we have in our department that we can customize to your needs, to put your names up top, up there, and to customize those and send them out to you. But essentially, if you see here, it's a fairly short form. It says petitioner up top, respondent, and petition to tribal courts. And the center portion here is where they would fill out the circumstances surrounding their request to use tribal courts, and that they're asking you to seek relief in tribal court. So the second way, again, is through a complaint. And again, complaints are generally filed for violations of ordinances, and they're generally filed by the VPSO, the VPO, the TPO, or by others as allowed by ordinances. Complaints are going to be filed with the clerk, similar to petitions, And they're really going to try to include the same information that we're looking for on a petition. And so that information is, we're going to have the name of the petitioner, we're going to have the name of the offender or the respondent, and we're going to have a description of the violation. And again, the last way that we can ask for tribal court is through referrals, transfers, or inter-tribal courts. And again, this is going to be something that's going to be discussed between two communities in advance, and their expectations, the roles, the responsibilities are going to be discussed prior to any cases being accepted, and that may be on a case-by-case basis, or it may be on a timeline basis that this community is going to hear cases for a certain amount of time, 6 months, 9 months, or maybe in certain cases, this community will hear cases involving child welfare for this community. So that's going to be something that's going to be decided in advance, or it should be decided in advance. It should be documented, and then that's how cases will be transferred to tribal courts. So again, what parties should be involved, right? So we want to make sure that when we're filing petitions or when a complaint is filed, that we are including all of the, what we would deem necessary parties, right? So we want to make sure we have the petitioner or petitioners, which are going to be essentially the victims in this case, and we want to make sure we have respondents or respondent, or who are going to be the offenders. And so you may ask, let's say that we have, let me give you an example, right? I live in SLU, and I have 2 dogs, right? I walk my dogs, there's no sidewalk. So let's say I'm walking my dogs one day, and big bag Denise and her big black car come up, and she hits my dog and runs away, right? And let's say David is with me, Judge Lang is with me, and Judge Rogar is with me. And they all witness this accident, right? Denise must have been in a really bad mood to hit my dog and run away, but it happened. And so I want to file in tribal court against Denise because she hit my dog and she ran away, right? So in that particular scenario, who do we think are going to be the victims? Right? It's going to be myself because I can't name my dog in a tribal court case, right? So it's going to be, I'm going to be the victim, and Denise is going to be the offender, right? But I have David, I have Judge Lang, and I have Judge Ragara who witnessed this particular event. Am I going to name them as victims, do you think? Witnesses, right. Right, and so the point of that, that awful story about Denise's bad driving is that, thank you Denise, is that we don't have to name all the witnesses, we don't have to name all the people that we're going to call on our behalf in the petition for tribal court. We should really be naming the victims or the petitioners and the respondents or the offenders, and later on during that case, the court could subpoena those people, David, Judge Lang, and Judge Ragara, to be witnesses and testify on my behalf or to give information to the court, but they're not necessarily required at the beginning of a court case to be included as that. All right? Another example, if you remember from our last training, we had Mickey and Minnie who had a daycare. Remember they had a daycare? They had Donald and Daisy who had a son, little D, who was attending their daycare. And Donald and Daisy were talking to Goofy one day, and Goofy has a big mouth, like everybody knows. And so Goofy was telling them, hey, listen, Mickey and Minnie are charging you 3 times what they're charging my kids, right? So Donald and Daisy were really upset. They wanted to bring it to tribal court. So in that instance, who are going to be the victims? And who's going to be the respondents, right? The victims are going to be Donald and Daisy, right? And the respondents, or the offenders, alleged offenders, are going to be Mickey Mouse and Minnie Mouse, right? And the witness, although I'm not sure if Goofy really speaks English, but the witness in that case would be Goofy, and the court could subpoena Goofy to go ahead and testify or to bring some information to the court. So let's move on. So case numbers. Another important aspect of our case numbers, right? And case numbers are really, they're a standard way, they're a unique way, they're an easy way of identifying cases without compromising confidential information, right? And so we want to make sure that we have in our judicial code or in your court codes how exactly case numbers will be defined, or if it's in your clerks that are handling that. But and we'll go through a couple ways of different formats and different recommendations and different things that we've seen. But case numbers really help to identify the identity of a case without compromising confidential information. They should be formatted in a way that are going to assist the courts and assist the clerks in identifying certain basic information about the case. And so some examples that we've seen are, sometimes they include the case number, or the case year, excuse me. if you have different types, or if you hear different types of cases, let's go through some examples. So again, the formatting of your case number is really up to your courts, it's really up to your community, and how you want to decide to do it. I would urge that it's probably really important to decide and to try to keep that format so that we have uniformity, and it may be easier for your clerks and your judges to really identify cases. But in this example, for example, we can have a case number. The first set of numbers could be the year, right? The next set of numbers could be the month, meaning the month that that case is going to be filed. The next set of numbers could be the number. So if we're in May and we're filing the fourth case this year, it could be 04. And the last set of numbers or letters could be whatever type case that is. So for example here, in my example here, number 1 is 2019 for the year, 05 because they're filing it in May. This would be the fourth case that they filed in May, so it'd be 04, and we're filing a civil case. So it'd be 2019-05-04-CIV for civil. Right, another example of that would be, instead of the year first, we're going to do the month first. So we're going to do the month that it was filed, which is 05, the year, which is 2019, the number of case that year or that month, which this one would be the first one, so it's 01, and the type of case, which is civil. So in this example, it would be 05-2019-01-CIV. Another one, and again, it's just rearranging things, would be the type of case first. So in this example, we're doing the civil case first. It would be the year next, so it would be 2019, the month, which is May, so it would be 05, and this is the third case this month that's being filed in our tribal courts, so it would be 03. So in this example, it would be CIV-2019-05-03. And then perhaps another way of doing it would be to take out the months. So we want to have the year it was filed, so 2019, and in this particular court, this is the 22nd case for 2019 filed, so it'd be 22, and this is a domestic relations case, so we're doing DR for domestic relations. So there really is no rhyme or reason, there's no requirement on how you format your case numbers, but you want to make sure that we're doing it in a way that is really an advantage to your community, and a way easy for your courts to decipher which case it is, and also for your judges to decipher. Does anybody have any questions on this? Okay, so you may ask, what happens next, right? We have a petition, we have it filed, what happens at that point? So when a petition or a complaint is filed with the tribal courts, what happens next is that the tribal court clerk is going to schedule a conference or a meeting with the tribal judges to review that petition and to decide whether to take that case. So simply because a tribal member files a petition to use tribal court, it does not obligate your tribal court to hear that case, right? It is a petition, so it's a request from a tribal member that your tribal court hear a particular matter. So what happens at this point? If your judges meet and they decide, yes, we're going to hear this matter, that's one step. Or the judges can meet and decide, no, we're not going to hear this case, right? And so if they decide, yes, we're going to hear this case, then what happens at that point is that the clerk is going to schedule that particular petition for a hearing, and the clerk is going to send out a notice of hearing. And if the judges decide, no, that we're not going to hear it, then the clerk will go ahead and notify the parties that, listen, the judges have decided to decline to hear your case. And that's generally done through a notice of declination or a denial form. But and it could be structured so that your clerk set it up or so somebody else sends it out. But those are the two avenues whenever somebody files a petition. So let's say that we file a petition to hear in tribal court, the judges review that case and they decide yes, right? The next step would be that we're filing a notice of hearing and we're setting it for a hearing, right? And so what the notice of hearing does, it provides to the parties, it provides parties to the case information about a court case, when it's going to be heard. Remember we said notice and opportunity to be heard. It provides when it's going to be heard, where it's going to be heard, and what it's going to be about. So at a minimum, the notice of hearing must include notice that there's a hearing and what the hearing will be about, and also the date, time, and the place of the hearing, right? So Jackie Chan is saying, but why? Why do I have to include this information, right? Why do we have to make sure this information is on here? And again, we have to remember that our requirement by federal and state law is that we provide due process, and that due process requires that we provide notice. So due process requires, again, notice, opportunity to be heard at a fair and impartial hearing, and part of that is through the notice of hearing. And so we were saying about best practices and recommendations and ways of ensuring that our tribal sovereignty and that our orders are upheld. This would be one way of doing it, by making sure that our notice of hearing is up to date and it contains the necessary information that we should be providing. Additional helpful information that you may find that you want to put on your notice of hearing, right? This is not required, but it oftentimes will maybe stop so many phone calls to the tribal court clerk saying, what happens, what can I do, can I appear by telephone? So this may be some considerations you want to put in your notice of hearing. We may want to include the rights of the parties, right? We may want to say, in our notice of hearing, you have the right to appear in person, you have the right to present your side of the story, you have the right to present witnesses. We also may want to put in information if your tribe will allow for telephonic hearings. If you allow for telephonic hearings, we may want to put information saying telephonic hearings are allowed by approval of the courts, with coordination with the court clerk, whatever the situation may be, but it may be helpful language to include in your notice of hearing. And you also may want to consider consequences of failure to attend. And what I mean by that, if we put a notice of hearing that describes where, when, and what, and we say, if you fail to attend, the hearing may go on in your absence, we may still determine the rights of you in your absence, you may want to include that language on there. And again, that will provide notice to that person that, listen, there's a hearing, we're providing an opportunity for you to speak. If you choose not to come or you choose not to speak, then your rights may still be adjudicated even though you have not been there. And so this is a copy of a sample notice of hearing, and briefly we'll go through it. It has all the information we just spoke about, right? It's saying, number one, we're going to put information about the notice of hearing, what the hearing is about. Number two, a hearing is going to be held on this matter at this place, on this date, at this time. And the two paragraphs in the bold are what we just discussed, right? We have a right, we're discussing the rights of the parties. You have a right to respond, you have a right to be present, you have a right to give written and oral testimony, you have a right to a fair proceeding, and then also it has information that you may appear by telephone, but the request must be made to the court at least 3 days prior to the hearing. Right? Does anybody have any questions? Okay. So the next thing I want to talk about is time requirements. So let's say that you have a notice of hearing, right? Is it sufficient if I give a hearing to Heather, hey, listen, I'm the court, I'm giving Heather a notice that you have a hearing in 2 days, right? The answer generally is no. In certain circumstances, they call for emergency hearings, but generally speaking, we want to make sure that we're providing reasonable notice to all people who are going to be attending tribal courts that there's a tribal court hearing. And why do we want to do that? We want to provide reasonable notice because we realize that everybody has a life, right? We have certain obligations with our families, with our work, but we want to make sure that we provide enough time that if people need to take time off of work, or if they need to make sure they have arrangements for babysitters or for the family, or if they're out of state or out of the community and they need to travel back, we want to make sure that we're providing enough time for them to make those arrangements and still attend tribal court. So what should we consider reasonable? Right, as far as time requirements. So again, we want to provide enough time for the parties to clear the schedules to make arrangements to attend tribal courts. Generally speaking, and again, your court procedures and your court operations and codes should really determine this and define this, what should be reasonable. But generally speaking, 14 days to 20 days would be considered reasonable. So that gives someone 2 weeks of notice of a court hearing to clear the schedules, to make arrangements, to notify the court that maybe you can attend, but 2 weeks is generally considered reasonable notice. But again, your judicial code should define exactly what is considered reasonable. Okay? And alongside with reasonableness, let's talk about timeliness of setting orders. It's really important that if we have an order, if we have a notice, that the court clerk is really timely in sending that notice to everyone. If we have a notice of hearing and we're giving them 14 days notice, but let's say we have a court clerk who is overworked, she's a little bit busy or he's a little bit busy, and he doesn't send that notice out for 7 days, then what happens to that 14 days notice? we're cutting it down by 7 days. And all the problems that we talked about why we should give more than 7 days notice exist, possibly. So you want to make sure that your court clerk has enough support, that they are getting notices out, that they're getting orders out timely, that there's not really a huge delay in lapse or time between the time that the order is signed or that the notice is given or signed by the judge and the time that the notice is mailed out to the parties. Okay? We want to make sure that we're doing it as close as possible. So let's talk about, we talked about service of process, right? Service of process essentially are certificate of mailings. The legal term or the definition really of that is it's a term for delivery of a summons, writ, or subpoena to the opposing party in a lawsuit. I really would like for us to think of it, it's a way of notifying the parties. So it's a way of providing notice to parties. Either notice of that there's a filing by the petitioner or the respondent, or notice that the court is sending out an order or a hearing or a notice. Again, court records, it's really important to preserve the sovereignty and to make sure that we have a written record of what's going on. So we want to make sure that we're documenting service of process, right? And again, we're going to go back to how do I comply or how do I perform service, right? Remember this, ABU. We can do service either by personal service, by handing that piece of paper to them. We can do service by mail. We can do it by phone, or we can do it, as David said, by published notice. And again, all that means is that we're taking that notice and we're putting it on their door. We're putting it on something that we know that they live at or something. So you may ask, so we have personal service, right? I hand this to Heather. That's personal service. How do I document that, right? Or how do we document personal service? Or how do I document that service was completed? So any type of service, in order to document that, the person who completes that service, so if it's me or if it's a process server or if it's the bailiff that you're handling, that's handling your service, what they're going to do is they're going to fill out a statement or certificate of personal service document, and they're going to file that with the court, right? We want to remember that we are trying as hard as we can to make sure that our court records are complete and that we're documenting everything that we do with the courts, so that if somebody comes back and say, listen, I didn't receive that notice, wasn't served, I have no notice, you went ahead and heard things without me, that we have something in our records that shows that yes, it happened. And so how we do that again is through a statement of personal service. And this document, it's filed with the clerk, it's mailed to all the parties, and then it becomes part of the court record. This is what a document of statement of personal service would look like. The top portion is the same, and essentially all it says I and the person that served service. So if I was serving on Heather, I would say I, Rick Garcia, state that on this date, on this date of, the 21st day of May, I personally gave a true and correct copy of the petition to use travel courts at 10:45 a.m. to Heather Canuck at the Cultural Center at this address. And so what that does is they sign off on this, it gets filed with the court, it gets sent to all the parties, and it becomes part of the record. So if Heather were to ever come back and say, listen, I never got a copy of that petition to your travel courts, we can pull this document up and say, yes, you did. Here is proof that it was served to you. Does anyone have any questions on this? I hope that we're all using, documents like this to show that service was completed. And you can really just change the language of this from personal service to I called Heather on the phone, I posted it on Heather's car, I posted it on Heather's door, I mailed it to Heather, or I mailed it to Heather, I posted it on her door, I kicked her dog, all that stuff, whatever you want to say, to show that that service was completed, but it's really important that we document that service was completed. And so you may want to ask, or you may be asking, how does the clerk, so we're saying, this is how I document service, right, as a person. But the clerk sends out notice of hearings, the clerk sends out orders, so how does the clerk document that things were mailed out, or that items were served on parties? And so how they do that is through a statement of mailing or a certificate of mailing. And essentially what the clerk does, if there's an order or a notice of hearing, the clerk is going to send it to all the parties, and she's going to document, or he's going to document on that notice of hearing, I certify that on this date I sent this document to these parties and they'll sign off on it. And that's going to serve exactly the same as a notice of service. And so this is what a statement mailing looks like. And again, this document, it normally would be attached to, let's say, every document that the court or the clerk is sending out that they generate. And they're going to state that on this date that I, the court clerk, state on this date that I sent a copy of this notice of hearing to the defendant, to the petitioner, to James Bond at this address. And they're going to sign off on it, and they're going to file this with the clerk or with the court, and it becomes part of the court records. So this would be proof or evidence that the clerk sent a certain document, which are very important documents, such as a notice of hearing or an order, to the parties that are involved. Here's some things, or some simple tips for clearly written orders, right? We want to make sure we have clearly written orders that everyone can understand. So some do's. We want to make sure that we're including all significant facts and information. We also may want to consider including who participated. For instance, on this date in front of me was Heather and Denise, or just Heather. You also want to make sure that we're really trying to step away from all the legal language and that we're writing in plain English, right? We want to make sure we write in language that people can understand. And so all the legalese, all the Latin words that we're so used to seeing sometimes, just get rid of it. Throw it out. There's no need for it. Just really write in plain language. So the don'ts, we don't want to use legalese, and here's some, like here to, where to, in rem, all that stuff that we don't really know or we don't really understand why people talk like that. Just get rid of it, right? In front of me was, or on this day, and we want to make sure that we're not using slang language, right? Slang. It may be normal for your community, but we want to make sure that we're using language that we can understand. You also don't want to insert personal feelings, right? I don't want to write in order, on this day, Heather and Denise appeared before me. Oh my God, I really don't like Heather's shoes. You may say in the back of your head, but we don't really want to put it on an order. I love your shoes. I'm just kidding. Okay, so I promise I have a couple more slides, and if so let's talk about case management really quickly, and I know that Annalisa and Natalie went over this last training as well as Darlene, so I'm not going to spend too much time on it, but Denise and Heather should have handed you a blue case file, right? Can everybody grab it and just hold it up for me so I know everybody knows what I'm talking about? Right. So what we want to do is we want to try to find an example of case management. So, and a lot of us, we're using written or we're using paper documents. So this is just an example of a case file. And so if you wouldn't mind just humoring me and going through it, right? So this is a case file, and how we arranged it, if you open up, right, the first page or the first tab is going to have your court docket. And so remember, we talked about anything that is sent out by the court clerk. We want to document what was sent, when it was sent, and to who it was sent. So this is that evidence here. So this is a case docket. It shows a date. It shows what was sent by a description. And then on the far right-hand corner, we're showing who it was sent to, either P, petitioner, or respondent. Right? And so how we have that set up is the first page or the first tab is always going to be your court docket. Okay, if you go to the next tab where it says Certificate of Service by Mail, this particular side is going to be all the documents that are generated by the court. So this is going to be your notice of hearings, it's going to be your orders, it's going to be your Certificate of Services, and we did it so that it's filed by the earliest document is going to be at the bottom, and the latest document is going to be at the top. Right? So if you go through it, you notice the first document, because it's at the bottom, is the notice of hearing for the petition to use travel court. Right? And then we also notice that that notice of hearing is also reflected on our docket. Okay, so this is just an example of a way you can set up your paper files or your paper case records. The first side, again, would be the docket information. The second side is going to be the reports of the notices or the orders that are generated by the courts. All right. If we flip it to the middle tabs, right, now we're inside of it. The first side, your left side, is going to be any documents that are filed by the petitioner, which are going to include things such as the petition to use travel courts, and also any responses to, filings that are filed by the respondent. And on the right side, as you open it up, are going to be documents that are filed by the respondent or the defendant. Did I lose anybody? Okay. Yes, yep. Petitioner on the left, respondent on the right. And if you flip it one more time, the back portion we have clerk notes. So these are notes that are done by the clerk that are outside the court records, that are for their purposes, that will help them in determining, helping them to write orders, and helping them to remember hearings. But please take this home with you guys. It's just a really, really simple way of organizing a court file and doing it so that you know what we're looking at. We're looking at the docket, we're looking at orders and hearings, we're looking at petitioner documents and respondent documents. Right, another way of doing it, let's say for instance you don't want to have all these tabs, it's confusing to you. You can have docket on one side and then all the documents on the other side and file it in chronological order, Just figure out a way that works best for you.
If you want to see an example of what he's talking about with the docket on one side and all the rest on the other, I have examples up front later after break.
Thank you, Denise. So we're going to quickly go through the next couple of slides. So what is case management, right? Case management is really just a system of organizing and protecting your court records and the court file. So you want to make sure we have documentation of what was filed, when it was filed, and by whom it was filed. The written record provided as part of a court file, it provides a summary of the court records. So in our courts, and so if we have, judges or court clerks that post personal information about tribes or about certain hearings, either while they're happening or after the fact, it's really going to diminish or it's going to destroy the confidence that we're trying to build in our tribal courts. And the last thing I want to touch upon really quickly, it's full faith and comity. And so these are. When I was in school, these are words that scared me because I didn't really I didn't want to try to understand it. So it's a way of, there are different standards for how the courts are going to recognize certain types of tribal orders. And so I would like for us to think of it as two, right? Full faith and credit is one, and comity is the second one. Full faith and credit, and these are a lot of words, I'll try to break it down. It refers to the mandatory adoption of another court's order unless the party objects and can prove deficiencies, right? And so the thing I want us to associate is full faith and credit is mandatory. Full faith and credit is mandatory, okay? Comity, it refers to the respect, the voluntary adoption that one sovereign gives to another, treating court orders as their own. So comity is voluntary, right? Full faith and credit is mandatory, comity is voluntary. Okay, that's the association I'd like for us to try to get. So let's go through some orders that our tribal courts do all the time, right? ICWA, Indian Child Welfare Act. ICWA is a federal law that requires states to give full faith and credit to tribal court orders. So if we go back to my word association, full faith and credit means what? Mandatory, right? So ICWA requires that state courts, mandates that state courts give recognition to tribal court orders for child protection, for adoption, for guardianship, and for certain juvenile cases. So again, it's not optional. It's not voluntary on the state's part. It is mandatory by federal law that they give, that they recognize your tribal court orders. Okay? The Violence Against Women's Act, VAWA. VAWA is a federal law that requires full faith and credit. So that means it's a mandatory requirement, right? It requires state courts to give full faith and credit to tribal domestic violence orders. So if we have a tribal domestic violence orders, can the state of Alaska say, I may recognize it? No, it's mandatory, right? We have to make sure that we realize that full faith and credit means it's mandatory. Another one that we may deal with, it's the Uniform Interstate Family Support Act. And let me back up. I want to give credit to Alaska Legal Services for this. This is taken off of their alaskatribes.org. If you haven't seen it, it's a great website, so this is information taken off of that. But the Uniform Interstate Family Support Act, it requires full faith and credit. So again, full faith and credit is a mandatory adoption, right? It's not voluntary, it's mandatory for certain child support orders and paternity orders. So again, full faith and credit means mandatory, right? Comity means voluntary. So State of Alaska in John V. Baker, it gives comity, so it's a voluntary recognition to certain types of cases, and again, it's unless it's shown that there was a fundamental unfairness with the court process. So again, the standards of recognition for court orders are full faith and credit, which is a mandatory adoption, or comity, which is a voluntary adoption of certain court orders. Here's a chart, and let's just go through it quickly of orders. So the adoption is governed by ICWA, right, the Indian Child Welfare Act. So is child protection and other domestic, other ICWA-defined cases. So we know that ICWA is a federal law, right, that gets full faith and credit, so that's going to be a mandatory adoption. VAWA gets full faith and credit for domestic violence orders, so that's going to be a mandatory adoption. Down at the bottom, John V. Baker, which is the Alaska Supreme Court, found that the state will give comity, so the state will give a voluntary adoption to certain orders from a tribal court, and that involves parent versus parent-child custody, divorce matters, or marriage. Now, the only, I guess, caveat, or the only way that they will not recognize this is if we're not providing due process to our tribal court participants. So again, the first presentation stressed the importance of due process and providing them notice, opportunity to be heard in front of a fair and impartial tribunal. So if we provide our tribal members and our tribal court participants with those three requirements, then all of this will follow, right? The state will have no choice but to give us mandatory recognition of orders, and the state will have, they will give us recognition of certain tribal court orders if we follow that.